Hello, YouTube. I'm Vince White. I'm an employment attorney, and we are going through and answering publicly posted questions from YouTube users right now, getting them the answers they need from an employment attorney. We have actually had a number of questions asked recently by YouTube user Andrew Macaluso, and I want to make sure Andrew gets some of the answers that he deserves, so rightfully. So, this question was posted on our September 24th of 2021 video entitled, What Constitutes Strong Evidence in a Workplace Discrimination or Sexual Harassment Claim? And on that video, Andrew asked, so is it to the attorney's advantage to go after anything that can show that people are being untruthful to increase the value of the claim and win? So let me parse out a couple things there. It is to the attorney's advantage generally to catch lies and to demonstrate when people are lying. That is very valuable. That is very important. But there's a question of context always in this industry, right? So, if somebody's lying about the donuts, and this comes up, right? Like clients will be like, yo, ask about the donuts. Ask about the donuts. You're like, what are you talking about? Donuts? This is the discrimination case. Like, no, the donuts. They wouldn't give me the donuts. And like, you ask about the donuts, and whoever you're deposing is like, all right, yeah, you got me. I lied about the donuts. I ate all the donuts. Okay. Well, this would really blow their credibility because everyone's going to be like, yeah, they were embarrassed of being a glutton. That was embarrassing. It's embarrassing they ate 7 donuts, right? It's not like you look at that lie and you're like, well, this person is part of a broad conspiracy to engage in workplace discrimination, right? By the same token, if you're asking, hey, did you guys all stand around and talk about how to retaliate against my client? Which is not something you would actually ask, but just hypothetically. And they're like, no, never. And then you can get like 3 people be like, yeah, we stood around and we all talked about how to get your client back for making complaints. Well, that's very useful, right? We have now really done damage to the credibility of this witness who lied, and we have a lot of room to maneuver tactically with respect to that particular witness, right? If that witness comes in with something detrimental to your case, you can be like, yeah, it does seem like your relationship with the truth is a little loose when it's bad for your case. Do you remember that time you lied under oath about the retaliation and every other witness we talked to said you were a liar? I mean, this is all tongue-in-cheek. This is not how any of this would actually be handled. But, you can see the general gist of where we're going with this. You're a liar! And you lie and you say bad things and they're not true and we can't believe anything that you say unless we like it, right? That's essentially the tack that you take when you catch them in a lie that matters. The donut lie is just like, not that great. Now, the second thing I want to note in your question, Andrew, is that you said increases the value of the claim and win. Now, it doesn't increase the value of the claim, right? Catching people in lies that are not about damage, right? If they're lying about damage, they could increase the value of the claim, right? If you have economic damages and you made $100K a year, they're like, no, he only made $50K. Well, catching that lie could potentially increase your economic damages, right? But if it's just a general lie, like, oh, were you there that night? No. Turns out that person was there. Okay, well, that's a lie. That might hurt that person's credibility and it might increase your chances of winning, kind of as you noted, but it wouldn't necessarily increase the value of the claim, right? A lot of these are going to be handled in a bifurcated fashion, where you have a liability hearing to see whether or not you win your case. And if you are victorious in your case, then there's going to be a damages hearing, right? It's bifurcated into 2 parts. They don't want to talk about damages unless you win. That is way, way more efficient. There's some detriments to the plaintiff there in there's a little less pressure on the defendants because they're not sweating under the burden of all this talk about how much they're going to owe you if you win, right? So that, you know, a non-bifurcated hearing process can put pressure on defendants. It can drive settlement sometimes. But the courts are just going to be more interested in the efficiency, the raw, unparalleled efficiency of bifurcating and saying, do you win or do you lose? Oh, you won? Great. Let's do damages now, right? So it's probably not necessarily going to increase the value of the claim. It's just going to increase the likelihood you might prevail at trial or hearing or arbitration or what have you, right? All right, Andrew, I hope this was helpful. If it wasn't, I will track the comments in this video to provide additional answers. I apologize that we're just getting to a lot of your questions now. I know you've been asking questions for a week or so, and we've been way behind. So it's the nature of free answers, I guess. It's just that we're, you know, I make these videos in bunches, and I post them over time, and I'm just getting to your questions now. But if it was helpful, like and subscribe, everyone. It helps me to help more people just like you.